And this is one area that they constantly talk about, that they have absolutely no power over. So it's something perhaps the Minister could look at as part of the new legislation. With that, I don't have anything further to add. I was asked to cover for Senator Bradford at short notice. I had a quick read of the provisions of the bill, and I have to say it makes eminent sense, and I'd like to commend it to the House.
Now that's Senator van Turnhout.
Welcome, Minister, to the House, and thank you, Minister, for continuing your practice of introducing bills in this House. And I recognise that the bill has a twofold purpose. Firstly, to amend the rules relating to certain proceedings heard otherwise than in public, and to increase the monetary amounts that the District Court and Circuit Court can award. And I'm going to limit my intervention to the first purpose, the proposed amendment to the in-camera rule in family law and childcare cases. And I do broadly welcome the efforts in the bill to strike the appropriate balance between the public interest and the privacy of adults and children involved in family law and childcare cases. And most people are very familiar with the variant of the Lord Hewitt's famous aphorism from 1924. It is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly be seen to be done. Indeed, the principle of open justice is a foundational common law principle, an important human rights obligation, and an enumerated provision in the Irish Constitution. The relevant article in the Constitution, Article 34(1), provides for exceptions to the administration of justice in public in special and limited cases. Such special and limited cases include those involving the most vulnerable in our society, and children are one such group. Children and families involved in family law and childcare proceedings present with a myriad of vulnerabilities and in very fragile situations. As such, there is a real danger of adverse effects for the parties involved in the immediate and long term. In light of the highly personal and sensitive nature of family law and childcare cases, privacy and anonymity of the parties should be protected from public consumption through media reporting. But a balance must be drawn, a balance this bill, I believe, purports to refine. And I agree that where the anonymity is guaranteed and respected, the facts of family law and childcare cases and the decisions of the courts should be published. This balance, if fully legislated, guided, explained and implemented, can account for the vulnerability of those children and families involved, while ensuring that key issues are brought to the attention of the public and debated through public discourse. Failing to inform the public and adopting the cloak of secrecy to the extreme has had disastrous consequences for Irish society in the past. A clear example of this can be seen with the injustices perpetrated against the women detained in the Magdalen laundries. That issue remained completely out of the public realm while injustices were occurring. It is very important that the public interest and the need to foster and encourage a greater understanding and trust in family law and childcare system is embraced and implemented. Also, the presence of the press will hopefully ensure that the recording of the precedent and the reasoning behind decisions and proceedings where there is no written judgment will now take place. But, Minister, I have a few questions about the practical application of the amendment to Section 40 of the Civil Liability in Courts Act 2004 as contained in Section 5 of the bill. The scope of the circumstances in which the court may exclude or restrict the attendance of press representatives and prohibit or restrict publication of certain evidence is very broad. Ultimately, this will be a decision for the judge to make, weighing the public interest considerations against the considerations enumerated in the bill, which include the best interest of the child, that the evidence is sensitive, personal information, that the evidence may be prejudicial to a criminal investigation or criminal proceedings, that the information and evidence is likely to lead members of the public to identify a party or a child, or where press attendance may inhibit or cause undue distress to a party or child. And my question is, Minister, will the court's adjudication over this complex balance be guided by the court rules, by practice directions, or by clear procedural guidelines? Who will be charged with making applications that the press should not attend? Is this the role of the guardian ad litem, the family member, the HSE, the judge? Is there an avenue of appeal to the decision to allow or to restrict the presence of the press? How will the manner by which the court arrives at this decision be actually monitored? My concern is that once information is disseminated, it cannot be taken back. And this is particularly concerning given the adverse effect or impact for the party concerned may far outweigh a possible monetary remedy, press apology or criminal conviction of those responsible for the publication of the material in question. Minister, be it a childcare case, a family law case or a case before the Children Court, I strongly recommend that any guidelines or rules relating to the media reporting of any case that a child is party to be proofed against the Council of Europe guidelines on child-friendly justice of 2010, which in fact were very much drafted by Professor Ursula Kilkelly of UCC in consultation with children right across Europe. And while not binding these guidelines on Member States, the guidelines are a standard of best practice, and their strength and relevance further lies in the fact that they've actually been substantiated by the children's own experiences of the justice systems. Minister, I've no doubt about the intention of this amendment, but I do have doubts in the absence of rules of implementation guidelines about its practical application on the ground. We only need to look at the Children Act 2001, which reads as an informed, welfare-focused and progressive piece of legislation. However, the weakness of the Children's Act lies in the distinct lack of any procedural guidelines being produced to date for the implementation of this Act. Guidelines are desperately needed, I believe, for the implementation of the Children Act and for this bill if their intention and spirit are to be realised. The children's rights referendum very much underpinned that the best interest of the child needs to be realised in practice. I've spoken to legal practitioners working in the Children's Court who are deeply concerned about what they have described as routine breaches of the Children Act in the Dublin Children's Court and in regional sittings of the Children's Court. And some of those examples, Minister, are the calling of the name of the child by the court-appointed registrar in the public waiting room, the former practice of district courts of including the name of young person with YP in brackets beside the name on the court list, or the presence of Garda and legal representatives unrelated to this specific case in the courtroom, which is mandated to sit in camera. And Minister, these malpractices cannot be tolerated and they do need to be remedied. And some of the remedies I think are quite straightforward. For example, why not ascribe a number to a child's case, which is communicated to them on their presentation at the court, and call out their case number as opposed to their name by the registrar for everyone to hear. We need to ensure the strict application of the in-camera rule by liaising with judges presiding in the Children's Court to ensure that only Gardaí and legal representatives directly involved with the relevant proceedings before the court are present in the courtroom. It's also clear that a child-friendly environment described by the International Standards of Best Practice and the European Court of Human Rights in cases such as T and UK and V in UK are not being implemented. Privacy is central to the creation of this environment. In the cases just mentioned, the European Court expressly recognised the adverse impact of overt media presence on the ability of children in question to effectively participate in the proceedings before that court. And so, as a result of my earlier concern arises as to who acts as the guardian of the child's privacy, and do those charged with the task fully understand the importance of the child's privacy and the full extent of the child's vulnerabilities and backgrounds. And this raises the bigger concern and question as to what training and specialisation the people who are currently representing and adjudicating on children have, especially in the light of state legal aid payments that legal representatives appearing in the Children's Court are receiving. Specialist training, I think, needs to be considered. And Minister, in the UK and Scotland, specialist panels have been set up where those involved must undertake specialist training. And what I'm asking the Minister is to give serious consideration that if somebody is receiving state legal aid payments in respect of a case in the Children's Court, they must have attended specialised training in relation to these court settings. Minister, I do note your proposal to bring amendments to the Coroners Act and the Civil Legal Aid Act, and I do welcome them, and I look forward to dealing with them at committee stage. I do welcome, actually, Senator Walsh mentioned about mediation. I look forward to the mediation bill that you plan to bring forward. I think it's very important. Where we can avoid things going to court should be, for me, especially in relation to children, is best. So I look forward to looking at developing other ways like family group conferences, as has been proposed in the 5th report of the Special Rapporteur on Child Protection, and that there are other ways. But I just wanted to raise those concerns. But broadly, Minister, I do welcome the spotlight being put on the Children's Court. Thank you.
Senator Batchik.
Thank you, Chair. And I'd just like to welcome the Minister to the House and welcome the introduction of the Courts Bill 2013. And I think it's receiving a general support, which is very welcome. And I would just like, Minister, to thank you in particular for introducing this bill here in the Seanad, which I know you've done on a number of occasions.